Mr. President, this is a photograph of the alien from the movie Alien. This is what you could end up looking like if you eat some of the raw, frozen shrimp being sent to the United States by other countries. Now, let me tell you what I'm talking about. In late August, the FDA found that raw frozen shrimp from Indonesia was being sold in Walmart, specifically in Walmart stores in Alabama, Arkansas, Florida, Georgia, Kentucky, Louisiana, Missouri, Mississippi, Ohio, Oklahoma, Pennsylvania, Texas, and West Virginia. It was being sold under the Walmart label called the Great Value label. If you eat it, how could you end up looking like the alien in the Alien? Because the shrimp was radioactive. I kid you not. It had a radioactive isotope in it called cesium-137. It'll kill you. Even if it doesn't turn you into the alien if you eat this stuff, I guarantee you'll grow an extra ear. That was bad enough. Obviously, the FDA issued a recall. A few days later, it happened again. The FDA and NOAA, which I'll talk about in a second, found that there were 26,460 packages of shrimp cocktail and 18,000 bags of frozen cooked shrimp being sold once again at Walmart and at Kroger's throughout the United States, containing the same radioactive isotope. How could this happen in America? This is unconscionable. I'll tell you how. Because that shrimp from other countries, which don't abide by the same rules that we abide by in America, which if you eat it will may turn you into the alien, and at a minimum will cause you to grow an extra ear. It's not being inspected. It's supposed to be. It's supposed to be inspected by the National Oceanic and Atmospheric Administration. We call it NOAA. It's part of the Department of Commerce. And yes, they're inspecting some of it, about 1%. On a good day, 2%. The United Kingdom inspects 50% of the foreign seafood coming into its nation. Even China does a better job than the United States of America. This is unconscionable, Mr. President. There's no excuse for it. I believe you testified that you think the Constitution should be interpreted according to its original public meaning. Is that right?
Yes, Senator.
What does original public meaning mean?
Yes, Senator. So the original part of that phrase refers to the fact that when we look at interpreting a text, we want to interpret it at the time it was.
Professor, look me in the eye and just answer my question. What does original public meaning mean?
It means the meaning that the text as it was understood by the public at the time it became law.
Okay. So you think Brown v. Board of Education was incorrectly decided?
Well, Senator, I think Brown versus Board of Education was correctly decided. Scholars who have looked at the original meaning of phrases at that time and the reasoning in that case sometimes question the reasoning of the case.
How many people in the United States of America at the time the Constitution was drafted do you think supported racial integration of schools? You think that was a majority view, do you?
Well, Senator,
Do
at the
you
time-
but first, Professor, do you think that was a majority view? Do you think most Americans at the time the Constitution was drafted supported integration of public schools, racial integration?
well, Senator, I don't know as as a sociological matter what percentage of people thought what at that time. I should point out that when we got to Brown versus Board of Education, of course, there had been several
But isn't
fundamental
that
amendments to the.
inconsistent with your statement that you have to interpret it according to original public meaning?
Well, what about the 14th Amendment and the 13th Amendment and the 15th Amendment? So original public meaning would mean
what
with
about
those. Well, that would mean we would interpret those amendments and those protections with the understanding of the text and structure at the time those amendments were ratified, which is different, of course, in the 19th century.
Let's go back to Brown v. Board. Look, I think Brown v. Board was correctly decided, and I suspect you do too. But if you say we interpret the Constitution according to the way that people at that time understood it, do you really think that people at that time in America supported racially integrated schools? Do you really believe that?
Well, Senator, I think at the time of the ratification of the 13th, 14th Amendment, and 15th, all which
But
have.
do you think people at that time supported integrated schools?
Well, Senator, on that particular question, I don't know it as a policy matter whether they were thinking about that particular issue. I think they certainly understood that the 14th Amendment, for which a massive part of this country essentially lost lives fighting the Civil War, certainly understood it to require racial
Professor,
equality.
You're not answering my question. I'm just trying to understand how you think. It's very easy to say, we interpret the Constitution according to its original public meaning, which as I appreciate your testimony, means the way people who read the Constitution at that time interpreted it. Is that right?
Yes, Senator.
Okay. Do you think that most people at that time looked at the United States Constitution and said, well, here it is, big as Dallas, racially integrated schools are required? Do you really believe that?
Senator, I don't know, but
And if you don't, I don't think you do, because I think historically that wasn't the case. So how do you square that with the holding of Brown v. Board?
Well, I guess what I'm trying to say is I think there are several steps in between that have not come up yet in our conversation, which is that you look at the text and structure, which of the 13th, 14th, and 15th Amendments clearly is requiring racial equality. And then over time, that has to be applied to different questions as they arise in context. So if the requirement is that all races be treated equally under the law, and the evidence shows that segregated schools is not doing that, then the requirement could be applied to integrate schools.
When you interpret a statute, you talked about interpreting it according to its plain meaning. What if the statute is ambiguous?
Well, Senator, if the statute
What do you do if it's ambiguous?
If it's ambiguous on the particular question coming before the court, I start with that phrase, but I also look at the context of surrounding provisions.
No. How ambiguous? I understand you define ambiguity as the language plus the surrounding language.
Yes.
I get that part. How ambiguous does it have to be? 51% ambiguous or just a little bit ambiguous?
So I have to say I would use the same approach essentially in all cases regardless of the ambiguity, because I would always start with the text, move to the surrounding provisions with the aim of fully understanding what Congress and the President had enacted. And only at that
Professor,
point...
I'm going to run out of time. With respect, answer my question.
Well,
okay, you're giving me professor talk. How ambiguous does it have to be?
I mean, I think under the Supreme Court's recent precedent in Chevron, it underscored that the court can never just rest and say it's ambiguous. The court has to come up with an answer.
Yeah.
So
why don't you just look at legislative history?
Well, you can't look at legislative history statements one by one because
Why not?
the individual
Why not?
intent. Well, Senator, with respect, because this body has its role in our system as an institution, not one by one. So your personal understanding of the law doesn't matter.
This will be my last question. I'm sorry. Coons went way over. So you're telling me that it doesn't help you at all to go through and look at the congressional record or read the committee reports or any of that? You don't think that's helpful in interpreting what a statute means?
It depends on the way in which it's being read. If it gives helpful statutory history, if it helps to refer to other portions of context, sure, but not to give it legally binding impact in and of itself. I would always be looking at a broad range of sources and use each of these statements as just one piece of evidence about what people understood the statute to mean at the time. So no, I would never take a piece of legislative history in isolation and give it legal impact.
Thank you, Madam Chair.
Thank you.
I thought I would just start down here and then move this way, if that's okay. Judge, what is the rational basis test?
Senator, I believe the rational basis test is going to be one of your least stringent tests, and whether a law has a rational basis for the outcome intended or the governmental interest that you're trying to obtain.
Okay. What if the legislature or the Congress, as the case may be, doesn't list a reason? What if they just pass the statute?
Senator, I would submit that probably happens many times, and I think it's the role of the court when determining such matters as a definition. I think it's the role of the court to determine whether the usage of that statute, using its wording in plain meaning, whether the usage of that statute is going to reach the governmental interest that you hope is obvious, but sometimes you have to determine.
So you just create the basis, the reason for the statute?
I don't think that you create it, Senator, but I don't think that most statutes, to be honest, I don't think that they tell you what they are trying to accomplish so much as they say, this is the law. For example, possession of a narcotic, that's going to say it's illegal to possess this. We determine if there's a rational basis that forwards the ends of the governmental interest.
Well, how do you determine if there's a rational basis? Do you look at the statute or do you look behind the statute?
Well, I think that you always look at the statute. Now, I think you also look at any other precedent or case law that is interpreted the statute. However, you look to the language of the statute to determine what it does and what effect that might have.
Okay. Counselor, let's suppose that a legislature passes a statute that says if you have a college degree or a more advanced degree, you don't have to take a driver's license test. And let's suppose that assume for a second that the federal court has jurisdiction over a challenge to the constitutionality of that test, of that statute, rather. What test are you going to apply, Counselor?
Senator, that would be a classification that doesn't turn on any sort of protected characteristic, and so it would be a rational basis test that would apply in that instance.
You don't see any suspect classification?
No, Senator.
You don't see any fundamental right?
No, Senator.
Okay, what if the legislature didn't provide, so you would use the rational basis test?
I would, Senator.
And you would uphold that statute?
I think there could be some rational basis that a court could conceive of to justify that statute, and rational basis is not.
So you would invent the rational basis, the reason for the statute?
That's generally how the test has been applied by the Supreme Court and by lower courts, and as a district court judge, I would be bound by that Supreme Court precedent.
Okay. Judge, tell me the difference, sir, between notice pleading and fact pleading.
Notice pleading, of course, goes to your due process issues under the 14th Amendment.
But what's the difference between notice pleading and fact pleading? We use two systems
Yes,
in
sir.
America, as you know.
Yes, sir. Notice pleading is based on, of course, that goes into your jurisdiction, your personal jurisdiction, and then the fact pleading, of course, goes into your subject matter jurisdiction.
What system does the federal judiciary use? Notice or fact?
No, fact.
Okay. Judge, I'm about out of time. Can I have 30 more seconds, Madam Chair? You heard me talk to the nominee for the Third Circuit about how she would interpret the Constitution, and she said that the Constitution should be interpreted according to its meaning as understood by the people in America at the time the Constitution was passed. Do you agree with that?
I do, Senator.
Okay. Let me ask you what I asked her. How do you square that with Brown v. Board of Education?
I would adopt a lot of what she said, actually. I believe the 14th Amendment, as it came in, addressed.
14th Amendment was later.
It was later. It was a reconstruction.
Can you turn your microphone on, please?
Sorry
Thank
about
you.
that. I believe the Brown versus Board of Education is correctly decided.
I do too, but when my friends, and I'm a textualist as well, but when my friends say, well, we have to interpret the Constitution in accordance with the way the average American viewed the Constitution at the time. I say, okay, that seems fair to me. Do you think that the average American at that time looked at the Constitution and supported and believed that it provided for racially integrated schools? Do you think that was a majority view at the time?
Senator, all I know is that Brown versus Board of Education is good law, and it was correctly decided.
And why do you think it was correctly decided? I agree with you, but why?
Well,
If you interpret the Constitution by looking at its public meaning at the time.
separate was not, it was inherently unequal, not equal. And
It was what?
I just don't believe that there's any appetite in this country for any type of de jure type of segregation. I believe
At the
that
time
case-
the Constitution was passed?
I'm talking about right now. I believe that it's good
No,
law,
but I'm,
Senator.
okay. I've gone way, way over. I'm sorry, Counselor, I didn't get to you.
No problem, Senator.
Mr. Director, you and the FBI, working with state and local law enforcement officials in Utah, have caught the assassin of Mr. Charlie Kirk. Is that right?
We have a suspect, yes, sir.
And you did that within 48 hours, did you not?
33 hours.
33 hours. Congratulations. We've had other political assassinations. Back in June, an assassin assassinated Representative Melissa Hoffman, Mr. Hoffman, Senator John Hoffman, and Mrs. Hoffman in Minnesota. You and the FBI and Minnesota state and local law enforcement officials caught the assassin within 48 hours, did you not?
I believe that timeline's correct, Senator.
Congratulations. Sometimes we miss the forest for the trees. Good work. Did Mr. Kirk's assassin act alone?
As I've said since the beginning, Senator, it is very much an ongoing investigation, And I can't speak to the state charges. That's for the state to address on their own, but we are providing them with the same investigatory findings reporting the department. And as I noted to Senator, I believe it was Cornyn or Hawley, that there are a number of individuals that are currently being investigated and interrogated, and a number yet to be investigated and interrogated specific to that chat room. So we are very much in our ongoing posture of investigation.
So others could have been involved.
Yes, sir.
Okay. I asked you this last time you were here. Kash, you remember Mr. Peter Struck and Ms. Lisa Page?
Yes, sir.
Mr. Struck was an FBI agent. Ms. Page was an FBI lawyer. They were both very aggressive anti-Trump political activists who allowed their political opinions to affect their work at the FBI. Is that a fair statement?
I believe their text messages and their testimony that was secured by the OIG and DOJ speak for themselves.
In fact, Mr. Struck and Ms. Page were having an extramarital affair, and at one point, Ms. Page texted Mr. Struck, quote, "Trump's not ever going to be president, right? Right?" And Mr. Struck replied, "No, he won't. We will stop it," end quote. Ms. Page resigned from the FBI. Mr. Struck was fired. They promptly sued the federal government and the FBI and Justice Department for releasing their emails, which revealed all of this. The FBI settled that lawsuit for $1.2 million, gave Mr. Struck $1.2 million cash, gave Ms. Page, who resigned. She wasn't fired, she resigned, she quit. Gave her $800,000. Who at the FBI made that decision to give them money?
That settlement was reached in the Biden administration when my predecessor was the director.
Who? Are you saying that Chris Wray did?
The only people that can decide that settlement are the Attorney General in conjunction with the director and the administration.
Okay, so you're telling me that Attorney General Garland and Director Wray decided to give them the money? Is
Yes,
that
sir.
right?
Yes, sir.
Okay. Now, when you took over the FBI, did you find instances of where, under the Biden administration, the FBI had weaponized the agency to push the political beliefs of President Biden?
Sorry, the last part.
When you took over the FBI, did you find instances of where the Biden administration had politicized the FBI to prosecute its political agenda?
Well, I won't speak for other people. Having been a target of that weaponization, having been a staffer on the House Intelligence Committee, having had the Justice Department weaponized against me for making the findings and leading the investigation of Russiagate, I know what that feels like. And that's why, as the FBI director, I'm committed to not ever have that ever happen again. But I'm also committed to fully investigating what was done, and that matter is still ongoing.
So I take it your answer is yes.
Yes, sir.
And you're firing those people, is that right?
Anyone that politicizes their job at the FBI will not work at the FBI.
Okay. You've heard some of my colleagues either implicitly or otherwise suggest that you have politicized the FBI to prosecute the political beliefs of President Trump. Is that true?
I don't know how that can be true when the stats that I cited, to include the 23,000 arrests, 6,000 weapons seized, 1,600 gang and criminal enterprise organizations, 4,700 children found and rescued, more enough fentanyl seized to kill a third of America. The men and women of the FBI are now on an apolitical mission, and this is why the numbers are historic in 7
Have you
months.
fired people because they voted for Vice President Harris?
I don't ask people who they vote for, and neither does the FBI.
Okay. But you've given people polygraphs, have you not?
Many people in the FBI take polys.
The FBI does that all the time.
Yes, sir.
Does it not?
Yes,
For
sir.
a long time, is that correct?
Decades.
All right. I want to ask you about the Epstein files. Have you seen the Epstein files?
I have not reviewed the entirety of it myself, but a good amount.
Would it be fair to say that Mr. Epstein trafficked young women, including, in some instances, minors, to himself?
That was specifically the allegations in the 2018 indictment in the Southern District of New York.
Okay. Who else did he traffic these young women to?
In terms of what the investigation, again, going back to 2008, Mr. Acosta, who limited the investigation and limited the search warrants and limited the parameters of the investigation, the only thing we are able to speak to publicly, because he was given a non-prosecution agreement by Mr. Acosta, is that first time period from, I believe, don't quote me on this, 97 to 2001-ish. And then when the Trump administration courageously reopened it.
Ash, excuse me for interrupting, but I'm going to run out of time. You've seen most of the files. Who, if anyone, did Epstein traffic these young women to besides himself?
Himself. There is no credible information. None. If there were, I would bring the case yesterday that he trafficked to other individuals. And the information we have, again, is limited.
So the answer is no one
For the information that we have
in the files?
in the case file.
Okay. Now, President Trump has deferred to the FBI and the Department of Justice with respect to the Epstein records. He says it is your call about releasing them. And I understand that the department and the agency have decided to release them in cooperation with the House committee. Is that correct?
Yes, sir.
So you're releasing them a little bit at a time. Is that correct?
We're releasing as much as we can, but we are limited by 3 different court orders, and the department went back to each of those judges to waive those court orders or have them lifted, and each of those judges declined.
Will you release all of them, or at least as many as you can?
We will release everything we are legally permitted to do so. We are continuing to work with the House on the subpoena request. We have substantially complied with it, but we will continue to release whatever we are legally permitted to do so.
Okay. I strongly encourage you to do that. Kash, this issue's not going to go away. And I think the central question for the American people is this. They know that Epstein trafficked young women to himself. They want to know who, if anyone else, he trafficked these young women to. And that's a very fair question. I want to know that answer. And I think you're going to have to do more to satisfy the American people's understandable curiosity in that regard.
Mr. Chairman, may I just respond to that? I agree, Senator. And what we have done, and just to remind folks, the Epstein case files existed in the 2 prior administrations, in the Obama administration and the Biden administration, and they didn't release anything. And there was President Trump in the first administration that renewed charges against Mr. Epstein. And I know it's a little complicated to understand, but what exists in the Epstein case files was a direct result of the limited search warrants from 2006 and 7, which hamstrung future investigations because of the non-prosecution agreement. And multiple administrations had the opportunity to look at the entirety of that case file and recommend prosecutions against anyone that was trafficked under Mr. Epstein and anyone that participated in that trafficking. And the only person to bring charges was the prior administration against Mr. Epstein. Now, I am not saying that others were not trafficked and others were not involved. What I am telling you is that based on the information we have, and we have continuously and publicly asked for the public to come forward with more information. If there is, we'll look at it. But based on credible information, we have released all credible information, and the information that the Department of Justice and the FBI never releases is information on investigations that are not credible. And we don't release the names of victims who weren't credible But in the same time, we don't release the names of victims who were credible. And so the information, that's by law. And so the information we are releasing now is historic, and it is also to the maximum capacity that the law allows. And I know that's not going to satisfy many, many, many people. But if they wanted it done right, then the investigation from its origination should have been done right, and he should not have been given a get-out-of-jail-free card to do jail on the weekends for 12 hours a day, and he should have been investigated fully for the entirety of his crime and criminal enterprise, not just from 1997 to 2001.
Counselor, as you know, it's hard to pass a bill in the United States Senate. Our founders intended that to be the case. And consequently, if a bill does pass, it's gone through a long, arduous process. A lot of reports issued, a lot of debate, and all of it's written down. Why has it become common practice, and do you support it, of ignoring that rich legislative history when you interpret a statute?
Well, Senator, I think the first rule of statutory interpretation is that the text is what's paramount. And that's because the text is what actually proceeded through bicameralism and presentment, which are really just the fancy.
Of course, it's paramount, but why can't the text be supplemented by looking at the history?
I think the legislative history can sometimes provide a tool to help interpret the text. And it's often in parties' briefs, and I would, of course, consider it that way. But it's just important to keep in mind its subordinated role in that interpretation, because the intention of any particular legislator does not have the force of law. Instead, the text does. So the legislative history and the intentions of specific legislators should never take primacy over the text or refute the text.
But it doesn't have to, does it, Counselor? It just gives you context.
I agree with that.
When you interpret a statute or write a brief, and you think that the language is plain, aren't you tempted to go look at the history just to make sure that your interpretation is correct?
It depends, I suppose, on the particular statute and the nature of the history at issue and the question.
But don't you want to just go take a peek? You look at the language and you say, well, this is as clear as thunder on a summer night. But maybe I'll just take a peek at the legislative history to make sure that I'm not out in left field. And the Supreme Court condemns that, does it not?
The Supreme Court does not uniformly condemn that, and there are certainly cases where, legislative history or statutory history has provided a tool.
Sure they do. I mean, originalism, and I'm not saying they're wrong. Please don't misunderstand me. I'm just trying to understand your perspective. Originalism and textualism is accepted even by the left of center justices. And I've read opinion after opinion, lower courts as well, where they say, well, legislative history, we can't rely on it.
Legislative history cannot be relied upon to trump the language of a statute. And so when the language of a statute really is that clear, Senator, there's not that much, and it bears directly on the question before the court.
Well, let me ask you something. Does the Supreme Court sanction looking to the Federalist Papers and interpreting the Constitution?
Yes.
Why isn't that legislative history?
The process for ratifying the Constitution is, of course, different than the bicameralism and presentment process that applies to statutory text. The Constitution was, of course, publicly ratified.
No, it's not.
Well,
you look at the plain language, don't you?
Yes. But in looking at the plain language, the question we ask is, what was the original public meaning of that language? And in the case of the Constitution, the original public meaning is elucidated by the debates surrounding its ratification. And those debates are really captured in the Federalist Papers, the Anti-Federalist Papers, the ratification debates, the notes from the Constitutional Convention, documents like that. So those documents can bear directly on the constitutional text in a way that is more legitimate necessarily than the statement of an individual legislator would be vis-a-vis a statute.
Well, then when we interpret the United States Constitution, and I agree with you, that's the case. I'm just asking you whether you think it ought to be the case. Then when we interpret the United States Constitution, Why do we let lawyers do it? Why don't we just hire history professors?
The history that judges are looking to in interpreting the Constitution and other statutes is primarily legal history. It's not something like, a biography of George Washington. It's instead things like statutes or, debates about statutes, the Federalist Papers. And certainly, I think law schools could do a better job and should do a better job, teaching students how to read that legal history. But it is fundamentally legal history. And then the task the judges have in reading that legal history is to draw analogies between that legal history and our modern times. And that analogical reasoning is, I think, a fundamentally lawyerly task the judges are particularly skilled at.
Thank you, Mr. Chairman.